we work to engage and retain membership of young lawyers from historically underrepresented groups and support programs and events that encourage equality among, all young lawyers of the Georgia bar. We've got a number of events and socials coming up, but I did want to draw your attention to our next event. It's on April 7th. It's again a lunch and learn between noon and 1 o'clock. And it's about the history of affordable housing in Atlanta, the effects of gentrification on formerly affordable Atlanta neighborhoods, and then also sort of the tenant protections offered by Georgia law. And it's presented by the co-director of the Safe and Stable Homes Foundation, Mr. Cole Taller. With that, I'd like to give a little bit of an intro into our speaker today. Really, really excited. Kameron Dawson joins us from A Better Balance, and she actually started with A Better Balance in 2019. They're located in, their southern office, I believe, is located in Nashville, Tennessee. She works on policy advocacy, litigation, and public education on issues ranging from pregnancy accommodations to paid leave. And she's engaged in numerous public speaking engagements. She recently received an award from the Alabama chapter of women in the NAACP for her keynote presentation on legal rights in Alabama. She graduated from the University of Georgia and earned her JD from the University of Tennessee College of Law, where she served as an executive editor of the Tennessee Journal of Race, Gender, and Social Justice. She also served as chair in the school student council on diversity and inclusion. Prior to working in A Better Balance, Kameron was also working for Teach for America. So we're really, really excited to have Kameron here today. Super excited that all of you could join us. And with that, if you'll take it away, Kameron.
Thank you, Michelle. And I just want to say thank you again to the co-chairs of this committee, Chanel and Essie, and for you for inviting me to speak today just about some issues that are currently addressing women in the workplace in Georgia specifically. And so today I just wanted to talk about how do we create a better balance? How do we ensure that barriers to racial and gender equity are addressed throughout workplace policies, but also state legislation? And how do lawyers from both sides address those issues and improve working conditions for workers? So just wanted to share a little bit about A Better Balance and take a step back. We are a national legal advocacy organization with offices in New York City as well as Nashville, Tennessee. We also have a DC office and an office in Denver, Colorado. And our main mission is to use the power of the law to advance justice for workers so that they can care for themselves and their loved ones without risking their economic security. Because we believe at A Better Balance that caregivers, parents, those that are addressing their own health needs shouldn't have to make that decision between caring for their own health and risking their paycheck or taking care of a loved one or a family member who has a serious medical condition and risking their job if there's not flexible scheduling or other workplace policies that can support their needs. And so I will say that some of our key priorities that we lead on are pregnancy discrimination and accommodations, as well as lactation discrimination and accommodations. But we also lead and support policies like paid family and medical leave, paid parental leave, and paid sick time. And we also work on issues such as caregiver discrimination, local democracy, or defending it against preemption in several states, including in the South, that preempt local laws, local governments from implementing laws like paid sick time or paid family leave to protect working families. And then I'll also say that we make sure that each of these laws has inclusive family definitions that includes LGBTQ plus individuals, but also non-nuclear families, as we have learned that many families don't just have a nuclear unit, but there might be grandparents, cousins, extended family members that need care. And for many women in particular, who are the primary breadwinner for their families, they have that burden of caring for those additional family members as well as themselves. And so I just wanted to share a little bit more about our work and also say that we do public policy work to make these laws better for workers, but we also have a range of strategies in our free and confidential legal helpline to not only help workers understand their rights, but also to enforce these rights as they become law. And so we do this mission through a variety of different strategies. And as I always say to folks, feel free if you have questions from what's covered today, if you're interested in being involved in these issues, feel free to email me. We do have a newsletter as well as social media, but we also work with plaintiffs' attorneys in pro bono opportunities as well as referral lists, which I'll share later today in the presentation. But here's my email and just a brief introduction of our issues. And so just to understand why it's important to address these issues, not just holistically in our environment, where workers live, what are the additional barriers that workers face, but it's also important to address how the workplace can actually be a negative influence on some of those barriers. And so here's just a couple of statistics on the status of women in Georgia today. As you can see, workplace supports are a critical component of working to support families and parents in Georgia. We can't continue to ignore how the workplace can often provide stress for some parents, especially when there's a lack of flexible scheduling and workplace supports. And in fact, we've seen that these policies may actually have an impact on the health and well-being of not just mothers, but also children. And so the March of Dimes recently gave Georgia a D- in its 2021 preterm birth report card. And this measures the rate of preterm birth rate in states. And Georgia has among the lowest in the country. And it actually reported that 11.4% of babies in the state are born preterm, and the preterm birth rate is even higher among Black women. In fact, it's 45% higher than the rate among all other women in Georgia. And so when we talk about not just benefits to businesses, but also benefits to the maternal health of mothers and babies by providing these workplace supports, we also can address the health and long-term rates for women and babies when we talk about what do pregnancy accommodations do for workers in Georgia. What does paid family and medical leave do for families in Georgia? So we believe at a better balance that no pregnant worker should have to choose between having a high-risk pregnancy or a healthy pregnancy because of their stress at their job, and they shouldn't have to choose between leaving their job in order to care for their health and avoid those high-risk outcomes. So currently, Georgia law does not explicitly provide for reasonable accommodations for pregnancy, childbirth recovery, as well as other pregnancy-related medical conditions. There is federal law, but I'll explain a little bit later how there are some gaps in coverage under federal law and how some of the policy opportunities in Georgia can really positively affect the health and well-being of mothers in Georgia. And also, there is not currently a Georgia law that provides paid sick time or paid family and medical leave to private businesses who need to care for themselves or their loved ones during a medical emergency. And so without the benefits of a paid sick time law, many workers, especially those in low wage earning conditions, are having to make that choice, which is really no choice at all, because oftentimes they are staying at work while they are sick because they cannot afford to go on unpaid leave or they cannot afford to lose their job, and it's actually negatively impacting their health and their family's well-being. So I also wanted to say that according to the 2016 data from the Department of Labor Census Bureau, women's participation in the labor force is at 71.2%. And so when we're looking at women who are the majority of the time the breadwinner for their families, this number is actually important because we're trying to support women as they continue to work in the workforce. How do we continue to keep that number strong, especially in the midst of this pandemic when millions of women have had to leave their jobs because of the lack of access to childcare, because of the lack of access to paid family and medical leave. And so when we talk about making sure that women's participation in the workforce is strong, we have to look at what ways that policy can help improve those measures and how can lawyers be influencing that law. And so one part just today is just about how can we ensure that women and mothers have the accommodations they need in the workplace to continue to have healthy pregnancies and also continue to have their lactation needs addressed through the law. So I want to start off with a pop quiz. And you'll see here that the first question is you announce your pregnancy to your boss, who says, as soon as you start showing, you'll have to go on disability because we can't have you looking like that in front of our customers. And is this illegal is the question. And I see some of you are already filling this out. And I'll give it some more time. Before we close our poll today. And I wanted to see if any folks have taken employment discrimination 101 in law school, or maybe attorneys too. So I really do appreciate y'all's responses. I'm going to close the poll now and see what we have. And so it looks like the majority of folks said yes, this is illegal, and 20% said no. And so let's see what the true answer is. So it is yes. So for that 80% who said yes, you are correct. And under the Pregnancy Discrimination Act, you cannot be forced out on leave if you are able to do your job and your workplace has accommodated similarly situated employees, or if under the Americans with Disabilities Act, there is a high risk condition and you're able to have either a reasonable accommodation that is your first choice or an alternative accommodation that is not leave is available at your workplace. Now, opinions of customers are not a valid excuse for discrimination or putting this worker on disability under the Pregnancy Discrimination Act. And so the goal is to ensure that the employee is able to talk to their boss to figure out an accommodation without being forced onto leave, especially if they are still able to work. But this is a common scenario that we hear on our free and confidential legal helpline at A Better Balance. And so just to go a little bit more into the Pregnancy Discrimination Act, it is a federal law. So that means that Georgia employers are covered under this law if they have 15 or more employees at their business. And it covers pregnancy, childbirth, as well as related medical conditions, which can include lactation needs or the need to express milk at the workplace. When we talk about who does this cover, it also covers private businesses with 15 or more employees, as well as local and state governments. And the law protects you as a job applicant. If you are interviewing at a job, your potential employer cannot deny you that job opportunity because you're pregnant. If they believe that, because you're pregnant, you're not able to do the job or you're not as hard of worker, that can be seen as unlawful discrimination in hiring decisions as well. And so when we talk about what are versions of discrimination in the workplace that pregnant workers face, for many, if they hear negative comments about their pregnancy and there is an adverse action like their hours are cut or they are fired, that can be seen as pregnancy discrimination. But for many, we have heard that they have been forced out onto leave the minute that they request a simple accommodation, such as a water bottle or a stool or even a modified schedule. And for those that are the primary breadwinners for their families, and they are the main source of income for their households, being forced on unpaid leave is simply not an option for them and their families. And it does put them on the line of poverty. especially when that is their main source of income and they can still work on the job. Um, Now, the PDA does kick in when you are an applicant as well as an employee, but if you request an accommodation, you can see if your other employees are being accommodated, if your job has a light duty position or other source of accommodations for workers who are injured on the job. The law does say that they need to treat pregnant workers similarly to those other employees. And so when your employer may be hostile or unaccommodating because of negative bias against a pregnant worker, or they're simply not knowledgeable about the law, that can actually put employers at risk for liability. Now, once you return from your pregnancy, the PDA does also cover those pregnancy related conditions as well as childbirth. And so, in many cases, pregnant workers may not be eligible for the FMLA, which is the 12 weeks of unpaid job protected leave. And so, if there is a need for recovery, 6 weeks to 8 weeks of leave, many employers cannot discriminate against a pregnant worker for trying to request that leave. But we've often heard on our helpline that some workers are returning to work as soon as 2 to 3 weeks after their childbirth because their employer simply denies their accommodation and their request, even if they have given other employees time off for an injury on the job or they have a short-term disability policy. And so I also want to talk about the why. Why is this law necessary? And discrimination came about originally based on sex under Title VII, and it was outlawed in the United States in 1964. But as I said, women were routinely being fired or expected to quit once they became pregnant, and that is what called for the amendment in 1978 to include pregnancy as a form of sex discrimination. And so the PDA is a minimum requirement, but employers can also offer more when it comes to accommodations. They can have a policy that specifically gives pregnant workers the right to request accommodations, or they can even provide maternity leave options above what the PDA requires to support working families. And so here's just some other examples of what we've heard from our helpline from pregnant workers in Georgia who are trying to navigate the conversations with their employers about their needs and their health. Now, an employer may not fire you because of your pregnancy. They cannot say if you are working in a restaurant that we don't hire those who are pregnant, you'll have to go. If it's an applicant, they cannot deny job opportunities by saying, why are you applying here when you're pregnant? You should be at home. This is a waste of time. And they also cannot say, we're going to cut your hours because you're pregnant. I remember, when I was pregnant, I couldn't work as much. These are all signs of pregnancy discrimination, especially if the pregnant worker has not requested these types of accommodations or this type of treatment. Now, if they have asked before for a modified schedule, then the employer can work with them to see, what type of modified schedule could be done, or if there are other options for accommodations. And like I said, we are a national legal advocacy organization, and we have done a study of cases in the country and reported that in our report, Long Overdue. And so what we found was there were numerous gaps in the law under the Pregnancy Discrimination Act. Now, in order to receive accommodations, a pregnant and breastfeeding worker might need to show that they are treated the same as those that are not so affected, but similar in their ability or inability to work, what's known as a comparator standard. And so, as we found in our report, which we recently updated last year, many workers, about 2/3 of them, had actually been unable to show what other workers were receiving, and they weren't able to receive that accommodation, and the standard was failing them in protecting their health and their financial well-being. And so what we saw was that because employees are forced to show that other employees are being accommodated by their employer in order to get their own medically necessary accommodation, they are running out of time. They are not privy to that information because they may be new on the job. They are not aware of what policies their job has, or how this accommodation can be done. But these are quick, inexpensive accommodations that employees are requesting, and the Pregnancy Discrimination Act is simply not covering them and providing them that relief that they need. And so this is a uniquely burdensome standard, this comparator standard on employees. And we actually just celebrated this decision last week on March 25th for the Young versus UPS case. But we're seeing now that many pregnant workers are unsure and unclear about this standard, and it's actually raising litigation. We found that some employers are unclear about what accommodations can be provided. And again, the Pregnancy Discrimination Act does not provide a concrete list of accommodations for pregnant workers. And so without the clarity in the law, this is really causing havoc for employers and employees. And so there must be a clearer law in place to provide relief for both. And before I get into what the policy opportunities might be, I also want to say that some pregnancy related conditions can also qualify as a disability under the Americans with Disabilities Act. And if someone works for an employer that has 15 or more employees and they have preeclampsia or gestational diabetes or a major medical condition that affects their day-to-day activities in a substantial way, such as their breathing, their ability to bend, their standing, that could rise to the level of a disability. And under the Americans with Disabilities Act, they are entitled to a reasonable accommodation unless it would be an undue hardship, which means it would be too expensive or too difficult for the employer to do. Now, the courts are it's a very different standard for what pregnancy related conditions actually qualify for a disability. And at times, several different courts have given different standards. And so again, this denies pregnant workers who have those severe pregnancy accommodation, severe complications, a chance to receive an accommodation for their pregnancy when they need it, even under this amended ADA standard. And I do want to note that pregnancy itself is not a disability. Now, some employers may have their own short-term disability insurance programs that consider pregnancy a qualifying disability, but under federal law, this is a difference in the way of getting accommodations. Now, the Americans with Disabilities Act, unlike the Pregnancy Discrimination Act, does provide a list of potential reasonable accommodations. And the EEOC, or the Equal Employment Opportunity Commission, has actually given some examples in their guidance for reasonable accommodations and undue hardship. And so that can include making changes to the workplace to reduce contact with others if a pregnant worker has a high-risk condition, temporarily changing some job duties so they're limiting exposure, modifying their work schedule if they have severe morning sickness or hyperemesis gravidarum, HG. They can try to work, later in the afternoon if they have morning sickness, or they can try to work longer in the nighttime if they're having pregnancy complications that are severe enough to rise to the level of disability. And then lastly, I also want to say temporarily transferring positions to something that avoids that strenuous bending or lifting heavy items can also be a potential accommodation, as well as requesting telework. And these lists of items go for not just pregnancy related disabilities, but also for those that may have high risk conditions that are chronic or severe that rise to the level of disability for both men and women. And so we continuously try to inform workers of their rights and try to talk them through the process of informing their employer that they have a disability and starting that interactive process. But for many women and pregnant workers alike, they are being denied these reasonable accommodations, which really does cause either preterm birth rates, maternal health risks, such as high risk conditions that can affect them in the long term or force them onto bed rest. And that does have long-term ramifications for their financial and health. So we want to try to address these conditions before they rise to the level of a disability so that pregnant workers can continue to work if they so choose, but also continue to have a healthy pregnancy. And so, as we see, 30 states and 5 cities have actually adopted what's called a Pregnant Workers Fairness Act to fill in the gaps of these two laws, so that those workers that may not have a disability may be able to request an accommodation with clear guidance, and they don't have to search for a comparator or someone who is similarly situated in their ability or inability to work. And generally, what these laws do is they require employers to provide reasonable accommodations for a known limitation that's related to pregnancy, to childbirth, or a related medical condition, unless it would be an undue hardship on that employer. And so here you can see a list of the 30 states that have implemented this law. It is gaining momentum. And in fact, in Georgia, there was twice now legislation introduced called the Working for Two Act that would provide reasonable accommodations for women in Georgia or birthing people in Georgia who would need reasonable accommodations in the workplace. Now, unfortunately, this bill did not cross over this year, but we are working with partners to ensure that the health and well-being of pregnant and postpartum workers is addressed in legislation. And these laws, again, they clarify what businesses need to do, as well as provide benefits for businesses, because it helps to increase motivation as well as retention of crucial employees. And it also keeps women and birthing people healthy while they continue through their pregnancy process. And so these laws help workers get the accommodations they need quickly and timely, without conflict, without litigation. And they can actually have this informal conversation with their employees to see, what may be provided to them. Now, just to go a little bit deeper into the process before we talk about the federal legislation, this process may look as simple as informing their employer that they need an accommodation because of their pregnancy, or possibly because of their need to recover from childbirth. And then the employer will work with them to see if there is either that accommodation available or an alternative accommodation that can be provided outside of leave. Now, for many, if there is not an accommodation that can be provided, then leave is still an option, and that may be, implemented as a reasonable accommodation, unless it would cause an undue hardship on the business. Now, the PWFA also states that an employer could not force a pregnant worker to take an accommodation such as unpaid leave if it was not needed by the worker. So it does also cover some of those situations that we talked about in the first pop quiz. And the bill would protect against hiring discrimination as well, stating that employers may not refuse to hire a pregnant employee simply because they would need an accommodation in the future. And so this does fill in the gaps of the Pregnancy Discrimination Act, as well as the Americans with Disabilities Act, and also provides clarity in the law for employees and employers. And so we still do need a federal Pregnant Workers Fairness Act, as we see that only 30 states have these stronger protections. And that is so workers don't have to hit the lottery when it comes to their business or the state that they live in. And so we're working as well on a federal Pregnant Workers Fairness Act that recently passed the House last year and is being considered in the Senate for a vote this year. And this, again, is similar to the state legislation that provides, crucial protections so that women would not have to choose between their health and their job, but also ensures that they are able to continue to talk with their employer and be a stable source of income for their families and themselves. Now, just to talk briefly, there are some new opportunities outside of pregnancy accommodations that can help support women in the workforce. I want to be mindful that there's also improvements to Medicaid, as well as other protections in the workplace and in the environments and households of women. And so this is just one tool in the toolkit for advancing equity in the workplace in Georgia for women. Okay, and with that, I'm going to launch our second poll. And so you'll see here the first question is everybody in the United States gets at least 12 weeks off work when they have a new baby. True or false? And the second question is okay, but that's okay because most employers provide paid maternity leave anyway. So that is a hint to the first question, but just want to see if what folks think. There's no right or wrong answer. Okay, and I'll just give a couple more seconds before we end the poll. Okay, and as you can see, so 100% said false to the first question. Everybody in the United States gets at least 12 weeks off work when they have a new baby. And also said false 100% to the second question. And let's see what the answer is. You were correct 100%. So only about half of the private workforce is entitled to leave of that length. And that is actually leave entitled under the Family and Medical Leave Act, or the FMLA that I referenced before. Now, when it comes to private employers providing their own paid maternity leave anyway, we've actually seen that false. Based on data from the United States Department of Labor Census Bureau, only about 23% of employees have access to paid family leave. And we'll just go into a little bit more about what are the policy areas that folks are organizers, lawyers are working on to make sure that these gaps are improved and access to these crucial workplace protections are actually being addressed in the legislature. Okay, so one thing is paid family and medical leave. And so this can come in multiple forms. When we talk about family and medical leave, we're talking about 12 weeks of paid medical leave for both your own care and caring for your family. That could be your parent, your spouse, or your child. And again, including that inclusive family definition to sometimes include expansive family members and LGBTQ plus individuals. And so when we see, what is being done to ensure access to these crucial protections, you can see that 9 states, including California, Colorado, New Jersey, have implemented these types of programs on a state level and have passed family and medical leave programs for their constituents. And unfortunately, nowhere in the South have we seen paid family and medical leave, but we are working on momentum. So we've seen the success of paid parental leave programs for state employees, as well as legislation that's been introduced on the state level to cover both private businesses and public employers in states such as Georgia. And this year, we were able to work with our partners on the ground to introduce legislation that would start a paid leave program in Georgia. And we're seeing, and building the momentum for that and in a long run program. Now, these laws, they would provide paid time off so that if you had a serious medical condition, you could take that time off as paid and ensure that you're caring for your health and well-being. But also, if you need time off for paid maternity leave or recovery from childbirth, this program would also ensure that you have the income and the time. As we've heard from many workers from our helpline, taking 12 weeks off unpaid, that is just not an option because of bills, because of stress on the job, and other financial burdens. And so that has caused many workers to return to work, 2 to 3 weeks after they have had a child, which is really against what many medical providers have advised, especially if you've had a C-section. It may look more like 8 weeks instead of 2 weeks. So this is really addressing the maternal health crisis, as well as ensuring that businesses can retain, critical and crucial workers. So just a few more statistics I found from the Department of Labor that only about 14% of workers receive, workers in the South specifically, receive paid family leave through their employers based on the data that the Department of Labor took. And low wage workers, especially those working in restaurants or retail, they're even less likely to have access to paid family leave, especially when they depend on every paycheck. And so when we talk about what are the benefits of paid family leave programs, they protect workers for whom are limited in paid sick days. And then they also make sure that those medical conditions are not reoccurring. And so they can make sure that they are addressing those needs in time, and it may save cost benefits in the long run for businesses. Now, when we talk about low wage workers, these are some of the workers who have been essential in this pandemic, and they have had high levels of public contact. They are our childcare professionals, our restaurant workers, our workers in hospitals giving help on the front lines. But these are the workers that are least likely to have access to paid sick days, which can have major impacts on public health. And just to talk a little bit about paid sick days, this is a different program from paid family and medical leave. This can sometimes look like 5 to 7 days of time off that is accrued at a rate while they work. But many times we've heard that employers are not providing any source of PTO or paid sick day. And so unless they are covered under the FMLA, workers really are at the mercy of their employer when it comes to taking time off for their health and well-being. And so the Family and Medical Leave Act is a federal law that provides 12 weeks of unpaid job protected leave during any 12-month period so that a worker can care for a new child or a serious family member or themselves when they are experiencing a serious medical condition. Now, because the eligibility requirements are so strenuous, many employees, a majority of them, are actually not able to qualify for this leave. So the three requirements for the Family and Medical Leave Act are: they have to have worked at their job for at least 12 months. They have to have worked for at least 1,250 hours, which does include some part-time workers if they're able to build those hours over time. But for many, they do have to work full-time in order to meet that requirement. And they have to have worked at a location that is within a 75-mile radius and has 50 or more employees. And so when we talk about who is this? Does this exclude? We're talking about those that are working part-time, that may be working multiple jobs in order to provide for their family or themselves. And we're also talking about those workers who have just recently started their job, or maybe within that 6 month to 11th month radius. And so it really is beneficial for states and even lawyers to be involved in this process to ensure that, these types of protections are being implemented for workers and for businesses so that folks can care for themselves and ensure that they're advancing gender equity so women can continue to remain in the workforce even if they are going through these hard times in their health. Now, I did say that this leave is job protected. So that means that leave takers can continue to have their health insurance coverage while they are on leave. And when they come back, they are entitled to be returned to their same or similar position, unless there is a business reason or like a mass layoff, or there are some other special circumstances as well. Now, employers cannot interfere with or retaliate against an employee for exercising their rights under this law. So if they request FMLA leave, they cannot be terminated. And at many times, their FMLA leave cannot be considered in their performance reviews if it is seen as being retaliatory towards those who are taking FMLA, or may have a negative impact on future employees taking FMLA. This law is overseen by the Department of Labor, and so we do work to see if more can be done to access that. And I did have another question, but it seems I gave the answer a little too soon. So we'll launch the quiz just to see if folks are engaging. But Can employers make all nursing employees pump in the bathroom, pump their breast milk in the bathroom? Alrighty. Okay, and thank you for those who said true. 19% and 81% said false. Thank you for those that were participating. Now, unfortunately, the right answer is false. So, under the Fair Labor Standards Act, you know, an employee, if they are covered under that law, they are entitled to pump in a private space that is not intrusive and is not a bathroom. Now, for some that may be excluded or exempt under FLISA, they are not, they may not be hourly or entitled to overtime, or they may meet the requirements under certain tests for earnings to be exempt under FLISA. Then they may not be covered, but they will be covered under state law in Georgia. And I'll go into that a little bit more to explain why that's false as well. And please feel free to put any questions in the chat. We definitely want to address those, or you can email me if we're close on time and need and have private questions that you'd like to ask. But just wanted to give an overview of some of the common issues we hear and how to address equity in the workplace. And so here's a little breakdown on the Fair Labor Standards Act. So the main federal break time law that provides time for nursing mothers is under the Affordable Care Act, but they do use the same requirements under FLISA to see who is covered under that law. So the Affordable Care Act does require employers to provide reasonable break time and space for an employee to express breast milk for their nursing child up to a year after the child's birth. Now, again, I said most FLISA exempt employees, those that may be salaried or not subject to overtime laws, are not covered under the Affordable Cares Act. This can include administrative workers, teachers, nurses that are excluded under this law. But if you are subject to FLISA, you are covered under the Affordable Cares Act. Now, assuming that you are covered, a worker would be entitled to a reasonable amount of unpaid break time, unless it could run concurrently with paid breaks that they have. But there may be additional protections under state law. Now, this space has to be clean as well as private. So it may feature a lock on the door or a sign to ensure that they are not facing intrusion from other employees or coworkers, but it also cannot be a bathroom. So, for many, they are able to pump at their desk or in a separate lactation space that is that provides space for cleaning as well as storing their tools. But this law does provide protections for some workers to ensure that they're able to pump milk after they have given birth. Now, there is a small caveat for those that have less than 50 employees, and there is an undue hardship defense. So if they have fewer than 50 employees and they have proven that there is a significant difficulty in providing this reasonable break time and space, employers may be excluded from providing these lactation accommodations. But they have to show that it would be an undue hardship based on their size, their financial resources, or the nature or structure of their business. And this again is seen by the Department of Labor. And even if a worker is not covered under FLISA, in Georgia, there is a specific lactation accommodations law that does cover many more workers. So if you work for an employer in Georgia that has one or more employees or a state agency or entity, you are covered by this law. And this does give paid break time to express breast milk for a reasonable amount of time and provide a private location in the workplace that's other than a restroom for you to pump in privacy. So this is why the answer to the previous pop quiz was false. Now, it does include the similar caveat as Affordable Cares Act in saying that for businesses with fewer than 50 employees, they may not be subject to providing paid break time and reasonable space if there is an undue hardship on their business by providing that paid break time or that space. but they still need to work with their employees to see what can be done to address their lactating needs. Now, this time off does not need to be paid if you are working, teleworking away from your work site, or if you are, working in a truck or driving, but you may still be entitled to that unpaid break time while you are at work under the federal law. And so I do want to also flag that this is a new law that was recently implemented a few years ago. And so we do talk with workers about their questions on this law, especially, or they can speak with the Georgia attorney if they have more questions and they think their rights have been violated. So lastly, I just want to end with some resources that we have for employees. We have a Talk to Your Boss About Your Bump, as well as your pump, that provides statewide information on both the federal and the state laws. It includes the health benefits, what to say, as well as how to talk to your employer about your needs for accommodations. And then we also have a Know Your Rights Hub that gives information not just about lactation needs or pregnancy accommodations, but also about paid family and medical leave, caring for yourself or a loved one, and what each of those laws may be under certain categories. And so I do want to say as well that along with our free and confidential legal helpline, which is 1-833-NEED-ADB, that employees can talk to us if they have questions about their rights. We also have fact sheets and guidance on these model policies at our website. Now, if you are interested in being on our referrals list, sometimes we do hear from workers in Georgia and we may not be able to take their case, or they may have questions about legal advice. We do refer them to attorneys who can provide them more insight into these laws. And feel free to contact my colleague, Marcella Coklatos, at her email if you are interested in being on that list, or you can also email me as well. And we'll make sure that we can connect you to workers who may be interested in pursuing their legal rights. We are able to take some cases, but for those that we may not, we do connect them with attorneys as well. And I just wanted to share our social media pages, just in case you're interested in learning more about either our work on the federal as well as the state and local level. And lastly, I will say too that we have a pro bono partnership program for attorneys that are interested in engaging in our work and supporting our work in research, as well as co-counsel opportunities, resources and in-kind support, as well as community Know Your Rights trainings and policy advocacy. And so if you are interested in working with us, feel free to join our program. We'll share this presentation and these links after the program as well. But we do, appreciate support from attorneys across the state in our public advocacy and policy research, as well as our litigation efforts. And that is all I have for today. And I just want to say thank you so much to the Young Lawyers Division for putting on this program and having me here today. So I'll turn it back to you, Michelle.
Oh, hi. So hi, thank you so much for the presentation. It was very informative. I don't know if anyone in the audience has any questions. I don't know if we have anything in the chat.
We don't have any questions in the chat right now, but if you're willing and interested in asking a question, then feel free to open your cameras and you can ask verbally, or as Essie mentioned, you could do so in the chat.
Sorry.
For those of you, okay. For those of you wishing to receive, oh, no problem. For those of you wishing to receive CLE credits, so long as you logged in and stayed for the entire session, you are eligible and you should be receiving future communications about that as well. Essie, are you good to go?
Yes.
Okay.
So what kind of, I'll start off the questions, like where do you see this most frequently, especially with issues with particularly like nursing and taking time off for maternity leave? Is it usually bigger workplaces, smaller workplaces?
Yes, Essie, that's a great question. So our helpline primarily works with low-wage workers or also workers who are in physically demanding positions. But we do often hear from some salaried workers who just have questions about how to go about this process. They've never, this may be their first pregnancy, or they're not sure how it works inside, and they just want to know before they walk into those conversations. When it comes to maternity leave, I often hear questions from those who are in retail positions, or they may work for a fast food chain, and they're not sure if they qualify for FMLA. They may just have heard about a leave of absence process or a personal leave. So they're really not sure, what is possible there. And they can sometimes work for franchises that have, multiple job offices, and, might be anywhere between 50 to 75 or even 20 employees. But we do often hear from some large employers, so it does run the gambit. And I think we're starting to also hear from teachers and state employees, as Georgia recently passed the 3 weeks of paid parental leave law last year, just to see, how can they engage with that law and, know their rights before they talk with our HR or other coworkers about it. So it is really the gambit of it all.
Speaking of that, do you all do legislative efforts, working with legislatures to create laws surrounding things such as paid parental leave or other issues surrounding that?
Yes, we do. So we are a 501c3, but we do support legislators and organizations that are on the ground in these states that are working on or interested in this legislation. So for many legislators, I will work on drafting bills that provide, the 12 weeks of paid family and medical leave, or give technical support for talking points, to ensure that these laws are, being communicated and messaged effectively. And many of the laws for the Pregnant Workers Fairness Act that passed in 30 states, they have passed with bipartisan support from both business and local organizations, people in the medical field. And so we really do engage all types of parties in making sure they understand what this legislation can do for their constituents.
Do you have any insight about, I know there's been a lot of talk on a federal level on these types of laws passing federally. Do you have any insight on that, or if we could expect to see that in the near future?
Yes, and I will say I primarily work on the state and local legislation in the South, but I do work hand in hand with our federal team, just because so much of the movement there cannot be done without the South. I'm a firm believer in that. And, although we saw in the Build Back Better package, there was an introduction of paid family and medical leave for the first time in centuries, really. And although it didn't pass in the Build Back Better package, I think it really does show that folks are engaging the conversation. And, especially in the South, I'm proud to know that we are engaging that, whether it comes to paid parental leave or state leave programs that provide both family and medical leave. I would say, in terms of the PWFA, the Pregnancy Accommodations Law on the federal level, we really are excited to see how the Senate goes. We're trying now to push for them to vote on this issue. Again, it passed the House already, and so now we're just awaiting a Senate vote before it goes to Biden's desk. But if you are interested in engaging those efforts, feel free to follow us on social media. We often do have sign-on letters, as well as, campaigns for social media pushes for that. And we're happy to engage with folks on that issue. So I just want to give that update too, that, a lot of this work is, we're not waiting on the federal level to provide these benefits. Workers and employees need these benefits now. And so states are really stepping up to the challenge and providing that benefit. But I will say the South is very interesting, because we have to address the issue of preemption. And, many states do preempt local governments and cities from providing these benefits for their workers, or so for private businesses in their localities. And so we do have to adjust our strategy sometimes because of that.
Does anyone else have any questions for Kameron?
And I will put my email in the chat again, just in case anyone has questions or is interested in supporting our work. As I said, being from Georgia and growing up here in Duluth and working in Teach for America in Clayton County, I really do have, a passion for teachers and for those in Georgia. So I just appreciate everyone's support and attendance today. And thank you so much.
Well, thank you for doing presenting for us. It was a really informative, and from the chat, I see that a lot of people enjoyed it, and I enjoyed it too. So thank you so much for taking the time to do this for us.
Thank you, Kameron.
And maybe I can just interject with a few more upcoming events just to reiterate. We sent out an email as a reminder for our next Lunch and Learn, which will occur on April 7th, and it's entitled Fair Housing Matters. Our speaker will be Cole Taylor. He is the co-director of the Safe and Stable Homes Project of the Atlanta Volunteers Lawyers Foundation. We also have our committee meeting, which will take place on April 12th at 7 p.m. That's Tuesday. We will be issuing information about how you can collect your Starbucks drinks as our refreshment for the meeting. And in that meeting, we'll share more about our upcoming golf clinic this summer and a social event in celebration of Pride Month. So stay tuned to that. Over to you, Michelle.
I don't have anything else. Thank you, everyone, and enjoy the rest of your day.
Thank you, everyone. Have a great day.
Thanks.
Thank you.
Thank you.